پارٹیز جو ہیں جیسے میاں صاحب PMLN کے سربراہ ہیں، لیڈر ہیں، وہ بھی اناؤنسمنٹ ان کی ہو گئی ہے کہ وہ بھی آ رہے ہیں. پیپلز پارٹی کی طرف بھی گہما گہمی شروع ہو گئی ہے. دوسری پولیٹیکل پارٹیز جو ہیں وہ بھی اپنے طور پر تیاریاں کر رہے ہیں. آج اس موضوع پہ گفتگو ہم کریں گے. میں آپ کو اپنے پینلسٹ کا تعارف کراتا چلوں. آپ کے جمال شاہ کاکڑ صاحب ہیں، فارمر اسپیکر بلوچستان اسمبلی ہیں، PMLN کے پہلے پریزیڈنٹ تھے، اب سیکرٹری جنرل ہیں صوبائی. میرے دوسرے مہمان ہیں سید بات علی صاحب ہیں، پولیٹیکل اکانومی پر کافی ان کی نظر ہے. اور اسکائپ پہ ہمیں جوائن کریں گے انور رضا صاحب، نیشنل پریس کلب کے پریزیڈنٹ ہیں اور پبلک ٹی وی کے اسلام آباد کے بیورو چیف ہیں. میں جمال شاہ کاکڑ صاحب آپ سے ایک آغاز کرتا ہوں گفتگو کا. یہ تھوڑا سا بتائیں کہ آپ کی پارٹی نظر آتی ہے جیسے اناؤنسمنٹ ہو گیا آپ کے لیڈر کا اور یہاں بھی آپ نے تیاریاں شروع کر دی ہیں. کیا آپ دیکھتے ہیں کہ الیکشن میں ماحول میں ایک دم سی تیزی آنا شروع ہو گئی ہے؟
اصل میں ذوالفقار صاحب بہت مہربانی کہ آپ نے ایک اہم موضوع پہ آج ہمیں مدعو کیا. آئین کا تقاضا ہے. جب تک آئین پہ مکمل عمل درآمد نہیں ہوگا، الیکشن نہیں ہوگا، پبلک کی ووٹ پہ منتخب اسمبلی نہیں آئے گی، تو آلریڈی پاکستان ایک کرائسس میں اس وقت ہے، معاشی طور پہ بھی ہر لحاظ سے. تو الیکشن وقت کی بھی ضرورت ہے اور عوام کی بھی ضرورت ہے، ملک کی بھی ضرورت ہے اور آئین کا بھی تقاضا ہے. تو انشاءاللہ الیکشن اناؤنس ہوگا اور آلریڈی تمام پارٹیاں ابھی اپنے سب بندی کر رہی ہے. ہماری پارٹی بھی قائد محترم نواز شریف صاحب کی بھی آمد 21 تاریخ کو، اور جب وہ آئیں گے تو مزید یہاں الیکشن کی رونقیں شروع ہو جائے گی.
بلوچستان میں ایک فضا تھی پہلے، کچھ دوسرے پولیٹیکل پارٹیز کی طرف جا رہے تھے، اب ایک دم لوگوں نے آپ کی طرف دیکھنا شروع کر دیا. ابھی آپ اپنی گفتگو میں، پہلے ہم انفارمل گفتگو میں کہہ رہے تھے، آپ نے کہا کہ 8-10 لوگ تیار ہیں اور ہم انتظار کر رہے ہیں کہ لیڈرشپ آئے اور اس کی موجودگی میں اعلان ہو.
صاحب بلکہ اگر صحیح غیر جانبدار تجزیہ کیا جائے تو پاکستان جب سے بنا ہے 2018 سے پہلے پاکستان کی آپ معیشت دیکھیں اور مہنگائی کنٹرول تھی، ڈیولپمنٹ شروع تھا، سپے کے پہ کام ہو رہا تھا، سب کچھ ہو رہا تھا. جب معاملی غلطی کبھی ہو جاتا ہے، غلطی تو چند سیکنڈوں میں ہو جاتی ہے لیکن پھر صدیہ اس کا نقصان برداشت کرتا ہے. تو اب سب کو پتہ چل گیا ہے کہ اس ملک کی جمہوریت کے لیے، عوام کے لیے قائد محترم نواز شریف صاحب جو 2018 سے پہلے جس سمت پہ پاکستان کو اٹھا رہا تھا، GDP گروتھ کیا تھا، مہنگائی، یعنی اب پیٹرول 70 روپے کا تھا، چینی 40 روپے کا تھا، گھی کا 5 کلو والا ڈبہ ہم لوگ 800 روپے 700 روپے خرید رہے تھے. آٹا کا کیا ریٹ
نہیں، لیکن پھر شہباز شریف صاحب آئے تو
نہیں،
پھر کہاں
وہ ہماری حکومت نہیں تھی، وہ ایک مخلوط حکومت تھی. انہوں نے کیا کیا کہ یہ پاکستان کو بچا.
اسٹیئرنگ ویل پر تو آپ بیٹھے.
نہیں، اکیلا بندہ کچھ نہیں کر سکتا ہے. انہوں نے بھی بڑی قربانی دی. قربانی یہ دی کہ یا پاکستان بچائے یا اپنا سیاست بچائے. تو انہوں نے کہا سیاست پہلے پاکستان کو بچائیں گے، جب پاکستان بچے گا تو سیاست پھر اس میں ہوگا. تو انہوں نے بہت بڑی قربانی دی. PDM کی جو اتحادی تھی، پارٹیاں تھی، اور آپ کو پتہ ہے پھر جب مخلوط حکومت چلانا کوئی آسان کام نہیں ہے، تو وہ بھی ایک بچ گیا. لیکن ہماری حکومت کو آپ 2013 اور 2018 کے درمیان آپ وہ فگر نکالے، آپ کو پتہ چل جائے گا مہنگائی کتنی کنٹرول دی، لا اینڈ آرڈر، بجلی کی لوڈ شیڈنگ، CPEC، سب کچھ ہو رہا تھا. لیکن پھر اچانک ایک تبدیلی آ گئی. تو اس کی وجہ سے آج ہم اس ڈگر پہ پہنچے کہ ایک دفعہ تو باتیں ہونے لگی کہ یہ سری لنکا والا ماحول پیدا ہوگا، ڈیفالٹ ہوگا، لا اینڈ آرڈر خراب، سب کچھ خراب ہوا. لوگ تو یہاں پاکستان چھوڑ کے جا رہے تھے. لیکن الحمدللہ اب جب دوبارہ الیکشن ہوگا اور پھر الیکشن ہوگا تو مجھے امید ہے بلوچستان میں بھی ایک ماحول بنا ہوا ہے. کافی سارے لوگ تیار ہیں PMLN میں شامل ہونے کے لیے، کیونکہ کو سمجھ آ گیا. تو چھوٹا صوبہ ہے لیکن سمجھ آ گیا ہے کہ جب تک اسٹرانگ پارٹی، اسٹرانگ لیڈر کی قیادت نہیں ہوتی تو ملک کے مسئلے حل نہیں ہوتے. تو آج یہاں کے میں آپ یہ پروگرام نوٹ کر لیں کہ انشاءاللہ اگر الیکشن فیئر ہو گیا تو مسلم لیگ نون مرکز اور پنجاب اور KPK اور بلوچستان میں حکومت بنا کر دی گی.
ठीक है। सैयद शहबाज अली साहब, आपकी जो है ज़्यादा एक्सपर्टीज इंटरनेशनल रिलेशन।
Tell us what was your first point.
My first point was that the legislative competence for the Parliament to enact the 2023 Act stems directly from a plain reading of Article 142, read with Article 191 and entries 58 and 55. That is my contention. First submission. Second, what I'm canvassing before your lordships is that the provision for right of appeal.
Before you come
No,
to
no,
right of appeal,
please go back. This is too wide. This is your contention is very general. Be precise. When you say 191, how do you relate 191? Which entry are you relating your 199 with? Are you relating it with entry number 55 or 58?
Both.
50?
Both. 50, entry 55 and entry 58. I'm relating it to both.
I think
My lord,
you said that in relation to the practice and procedure bits of
yes,
the Act, you are relating it to entry 58.
yes.
Okay, now the difficulty I'm having with that is I've told you what I think one aspect of it is, but coming now to the other aspect, you start with law under 191, you then relate it to a legislative entry which is 58. I'm just talking of practice and procedure part because and then you read it back, the principles of interpretation of legislative entries, you read them back into 191. Now, the difficulty that I'm having here is that if we look at 191 and think in terms of legislative competences, then the subject matter of that legislative competence is the practice and procedure of the Supreme Court. And on your reading of this back and forth, this has to be given the widest possible. The law enabling power has to be given the widest possible amplitude and interpretation and understanding. You will recall that the 1956 Constitution and the 1962 Constitution, both of them had specific legislative entries with regard to the Supreme Court. Right? Specifically with regard to the Supreme Court. Jurisdiction, powers, this, that, and the other. Right? Now, the Government of India Act 1935, which also served as the first constitution of Pakistan up to 56, in relation to the federal court, the 7th schedule did not have any such entry, other than, the only entry was other than what is now entry 55. But there was no specific entry. The interim constitution structurally, as does the 1973 constitution, they revert the position back to Government of India Act 1935 in terms of the legislative competences, because I'm now focusing on your entry 58 argument. If that argument is correct, it seems to me that that indirectly resurrects a legislative entry with regard to specifically with regard to the Supreme Court, which has been removed from the legislative lists, and it recreates indirectly something which the interim constitution and the 1973 constitution very firmly say, as I understand it, modeling themselves on, in this regard, on the 1935 Government of India Act, that indirectly brings in, resurrects the legislative entries that were there in 56 and 62, which to me creates this problem. Firstly, as my learned colleague some while ago said in a different context, but this is indirectly amending the Constitution. Secondly, it seems to me the very broad manner that you are talking about with relation to 58, I think that puts in doubt whether law as used in 191 is supposed to be an enabling power at all, because you are now creating a legislative competence as you say, in the widest, broadest possible terms, which does not exist in the Constitution. What would you say to that?
Lord, my humble submission is that, and reading of Article 191 is that when it says that Supreme Court may make rules and they shall be subject to the Constitution and law, I read it that on that issue, on that subject, there is a law or can be a,
मैं आपकी जो है ना, I'm sorry to interrupt you, but I'm trying to understand जिस तरह आप इसको 58 से लिंक कर रहे हैं ना, the practice and procedure parts of this act, आप जिस तरह इससे लिंक कर रहे हैं, तो then necessarily the subject, the legislative power or competence of law in 191 has to be in the broadest possible terms. But that is only possible, it seems to me, if the 73 Constitution had retained what was to be found in 56 and 62, namely specific. आप जरा पढ़ें तो सही, दीजिए साहब को 56 Constitution दें साहब को और 62 Constitution दें, उसमें वो legislative entries जो Supreme Court की हैं वो पढ़ें तो सही ना. आप तो उस चीज को रिक्रिएट कर रहे हैं इनडायरेक्टली. आप काइंडली रीड दोस लेजिस्लेटिव एंट्रीज.
मलूड,
आप पढ़िए वकील साहब जी, पहले पढ़िए तो सही ना. 56 का है 5th शेड्यूल.
Is this your argument, Mr. Zaid Ibrahim?
No, I'm trying to. I'll read
Yes,
56 Constitution.
5th schedule.
I think it's entry number 16.
Fifth, yes. Entry number?
I think maybe 16.
16. यहाँ पे
It's in the Federal Legislative List, 5th schedule. Entry मुझे याद
16 बोल रहे हैं
16. हाँ 16 है ना, एंट्री 16 देखिए, फेडरल लिस्ट एंट्री 16.
The Constitution, organization, jurisdiction and powers of the Supreme Court, including contempt of such court and the fee taken therein, persons entitled to practice before the Supreme Court.
और अब आप इसकी देखिए 62 कॉन्स्टिट्यूशन की, वो भी चले ना रहने दें, वो more or less along the same lines, just to save time. तो ये जरा काइंडली बताइए ना कि इसके अंदर जो आप जिस तरह रीड, उसका इम्प्लीकेशन जो है, उसकी जो लॉजिकल कॉन्सिक्वेंस है, does that not revive a legislative entry that perhaps consciously the interim constitution and the 73 constitution?
Sometimes, logical consequences flow differently for different people.
I'm waiting for your answer.
My answer is that it does not, in my view. My answer is that I am reading Article 142A as being the powers, that's where the powers stem from, the power to legislate, in relation to matters provided in the Federal Legislative List. The Federal Legislative List, entry 58, and if we can maybe read it perhaps.
Mr. Zahid Ibrahim, could I just to rephrase what you were saying, and if you want to look at it this way, maybe, perhaps, that you start off with 142A, jump on to 58, and now you bounce back to 191.
Yes.
But this time when you come back to 191, you look at it as an entry because 58 is telling you to look at it. And all you do this time when you read 191, you're looking at the legislative competence only. And you just say there is law mentioned which could do this, and that solves the mystery.
That is what I've been trying, that is my submission.
Are you
142.
Are you going in for the part relating to within the legislative competence of Majlis Shura,
Yes.
or relate to the federation? Which part?
The first part. Fine.
But the first part in itself doesn't give specific direction of competence किस चीज पर है? And as was said earlier,
Competition,
it says it
competence
would
in-
be anything and everything. So how do you say that from entry 58 matters which under the constitution are within the legislative competence? So then the question is, where under the constitution are you getting the competence from?
191.
191.
And you're reading
doesn't
subject to
provide
the
competence.
constitution?
So what is happening is, as I see it, is that you, as I said, from 142 you jump on to 58. 58 simply says, go back into the constitution and see if there is any legislative power.
Yes.
I come back to 191, but looking at 191 differently now. I just have to look at the competence, and I see that it says that there could be a law which could regulate practice and procedure. So we just have to look at the subject matter. This time round, coming back after 58, we just look at the subject matter.
That is my reading. My lord, with regard to
Mr. Zahid, you can always say, you don't have to agree with me. We are here to hear your contentions.
and I have respectfully
You can.
said it
I mean,
very-
you've been polite. You can say,
No, no.
don't need to agree with me.
I think it's fairly
But
clear.
Mr. Zahid, we have to
I've only
understand, we have
expressed.
to understand what you are saying.
Yes, of course, and I've only
We
expressed
may
my
agree with you,
submission,
we may
of
not
course.
agree with you.
Of course,
But
and
surely a judge sitting on a bench of the court is entitled, when a submission
And I
of high
appreciate those.
constitutional importance is made,
I appreciate those
to
observations.
appreciate that.
I appreciate
And I
those
think you've
observations.
appeared me enough times to know that this is the way
I appreciate those observations.
that's the way I look
चलिए
at
आगे
things.
बढ़े. आगे next point
And
please
that's the way
चलें.
how.
I'm grateful.
that's
Zahid
the
साहब
way-
आगे
I'm
बढ़िए
grateful,
please.
sir. The second point that I wish wanting to submit is that the right of appeal is nothing but extending the jurisdiction of the Supreme Court, which is provided under entry 55. And why do I say that? First, in relation to extending the power of the Supreme Court, the argument is that this can only be done where there is express authorization. And the counter argument is, where is the express authorization? There is none. And therefore, this is a redundant provision. You can't read redundancy into a constitutional provision. So, express authorization, I find it in a reading of Article 10A and 2A. And there is a judgment on this that I wish to cite, my lord.
No, just a minute. Express authorization under Article
10A, right to fair trial,
and Article 2A.
objective resolution.
No, and Article 2A.
Ji.
So is it your case, now these are, as the very appellations A indicate, that these were not there in the Constitution as originally enacted. Entry 55 has never been touched. It remains as it is. So is it your case that prior to these articles being added to the Constitution, the answer would go the other way?
My,
Let's look at the Constitution on the commencing day.
sir,
If suppose on that day or the next day, Parliament had made this law with regard to the right of appeal, there was no 10A then, there was no 2A then, what
Sir-
would you say, what would the answer be?
my answer is, and the question I think is connected to the larger question that 185 में अपील जहाँ पे कॉन्स्टिट्यूशन ने प्रोवाइड करनी थी कॉन्स्टिट्यूएंट असेंबली ने वो कर दी अगर उन्होंने नहीं दी है 184(3) में टू बैड go back, make a constitutional amendment. That is the argument, right? My contention on that is that the parliament said, yes, हम 184 में अभी नहीं दे रहे, but हम ये power दे रहे हैं legislature को कि entry 55 में हम डाल रहे हैं कि you can extend your jurisdiction if at a later stage.
The word used is not extension. The word
Extend.
used is enlargement.
Enlarge the jurisdiction.
Now,
yes.
how do you interpret the word enlargement? As I see it, enlargement is of something which already exists. There is no appeal which exists. So how can it be enlarged?
Mr. Zahid, there could be two interpretations to that. I mean, my loud thinking that enlargement in this entry would have two sets. One is the existing jurisdiction being enlarged. The other is creating a totally new jurisdiction. Still, the Supreme Court's jurisdiction gets enlarged. So it doesn't really matter. The express provision is required for the existing provisions, but for a new jurisdiction, you don't need any.
And
because
when you have two fair interpretations possible, which one do you go to? You go to the one
You see,
where the law will survive.
दो चीजें हैं ना, creating and in creating you are enlarging. Where is the power to create a new jurisdiction?
So that is the where enlargement would come in. Most respectfully, sir.
Yeah,
Discuss-
agar if we give enlargement a restrictive meaning, then can you give me an example when is it ever applicable then?
Sir, if I may
I mean, I
just-
can't think of a scenario, maybe you can help me think of a scenario. If we give it a restrictive meaning, the enlargement is different from creation of jurisdiction.
But
Then
also-
where will it come into play when, let's say this act did not exist and I asked you, please enlarge the Supreme Court's jurisdiction, what would you do?
It's a matter of semantics, you see. I mean, it's just a word in the sense that suppose if there is an appeal provided, would you not say that the jurisdiction of the Supreme Court stands enlarged? So it's just a word, I mean, to be, and we've read the principles, widest possible interpretation. So
This
we cannot be lost in the word.
Enlargement of jurisdiction can be read with Article 175(2) or not, because it is a case of jurisdiction. No court has any jurisdiction unless conferred by the Constitution, by or under the law. So if you read the enlargement, is it not the appellate forum is not an enlargement of jurisdiction to the original jurisdiction of Article 184(3)?
Indeed it is.
So it would be read with Article 175(2) or not, where
Yes.
the powers have been given.
Yes, certainly.
But the law,
My lord, what-
but the law over there would have to be a law that Parliament is capable of making, which brings us back to the same question.
What will go back to the same?
But you see, enlargement का तो example 185 में ही दिया हुआ है, और वो जो आपके वो थे ट्राइबल एरियाज की enlargement, वो एक्ट का नाम ही था enlargement of jurisdiction. लेकिन आपसे तो मैं सवाल कर रहा हूँ, उसका मुझे बताइए ना, आपने अभी 10A और 2A का जिक्र किया.
ठीक।
तो I'm giving
और
you
एक
an
चीज
example.
और है इसमें,
आपने कहा
जाहिद
कि
साहब,
एक-
मिस्टर
एक
जाहिद,
उसके अंदर
आप सुन लें, फिर मैं आपको एक और चीज उसी के
आप
जवाब
उसके
में बता
अंदर जो
दीजिए।
है एक बात आप कर रहे हैं कि जी पार्लियामेंट के पास शुरू से ही पावर था, उन्होंने कहा जब हमारी मर्जी होगी हम लॉ बना देंगे. इज दिस योर आर्ग्यूमेंट?
पार्लियामेंट ने उस वक्त
नहीं बनाया लॉ, ठीक है,
नहीं बनाया,
1970
बट ये
but you say that inherent in entry 55 is the power to create an appellate right of appeal in respect to 184(3). Is this your argument?
absolutely
Yes.
yes.
Okay.
My lord,
So that
Now, appeal, is it a procedural matter or is it a substantive right?
it's definitely a substantive right.
It is a
It is-
substantive.
yes, yes.
Learned Counsel.
So you
Learned
can create
Counsel.
a substantive right by implication.
Not by implication. I'm
Learned
not
Counsel.
creating it by implication. I am saying that the injunctions of Islam mandate that you cannot deny right of appeal.
Learned Counsel.
And the Honorable Supreme Court of Pakistan says that this is what the injunctions of Islam say.
Which case is that? Which case is that?
Trying to get to that PLD 1989 Supreme Court 6.
But the Honorable
Supreme Court, page 6.
Honorable Supreme Court also says that the lawmaker, if he intended to the constitution makers or framers of the constitution, if they had intended to provide an appeal, they would have done so. And if they by intention did not do so, and 185 comes after 184, then be it so. I mean, if
Perhaps-
they did not provide an appeal and now the Constituent Assembly wants to provide an appeal, let it do so. But let it be by way of a constitutional amendment,
My
and
lord,
not by
another way of looking
by,
at
by stretching entry 55 out of shape.
My lord,
Learned
another way
Counsel.
of looking at it, if we look at 184(3), वो तो इस्तेमाल ही नहीं हो रहा था. Right? Later on, it started, and that is the reason that the parliament
कब
perhaps-
इस्तेमाल होना शुरू हो गया? किस आप बताइए ना, जो इस्तेमाल नहीं हो रहा था.
No, no.
Make your point.
I'm trying
तो चलिए आगे बढ़िए ना.
Learned Counsel.
जरा आप चलते रहे ना, थोड़े आर्ग्यूमेंट्स आपके हम नोट कर लें पहले.
In
जाहिद साहब प्लीज आर्ग्यूमेंट्स बताएं.
Zaid Saab,
If I may, this is
Zaid Saab,
identified.
as I've understood your argument,
Welcome to the full court.
entry 55 is very crucial. It gives competence to the parliament in two ways. One is enlarging the jurisdiction. The jurisdiction which already exists, it's enlargement of that. And secondly is to confer supplemental powers. That is in the context of the existing jurisdiction. So, any jurisdiction that exists that can be enlarged. It is not a creation of a new jurisdiction. And it is the existing jurisdiction which is being enlarged. It is unlike Article 185, where the original jurisdiction is of the high courts of other forums. It's only the appellate jurisdiction that has been created and vested in this court. Secondly, coming back to the question, why was there a need? If as interpreted by this court till 1988, if 184.3 had been exercised the powers the way that originally were intended by the framers of the constitution makers, there wouldn't have been a problem. The problem started after 2010, when everyone was speaking about it. The voices came from the lawyers, from everywhere, that the power was being abused, and we need to acknowledge that. So now, in that historical context, merely the jurisdiction has been enlarged.
Indeed, sir. In fact,
well, the first case that happened under 184.3 was in 1976.
but the floodgates opened later.
Uske baad 184.3 has been exercised, yes, progressively, but then the law developed.
Yes, of course it did. So, if I may just come to page 12.
निगरान हुकूमत इंतखाबात के लिए तमाम मतलूबा वसाइल की फराहमी यकीनी बनाएगी। इलेक्शन कमीशन के अहकामात पर अमल दरामद में मुआवनत करेंगे। दहशतगर्दी और सिक्योरिटी चैलेंजेस का सामना है, शहरियों का तहफ़्फ़ुज़ अव्वलीन तरजीह है। ज़ख़ीरा अंदोज़ों के खिलाफ मौसर कार्रवाइयों के नतीजे में अशाए खुरोनोश की कीमतों में इस्तेहकाम आया। दोस्त ममालिक पाकिस्तान में अरबों डॉलर की सरमायाकारी में दिलचस्पी रखते हैं। दिसंबर तक अच्छी खबर मिलेगी। निगरान वज़ीर आज़म अनवारुल काकड़ की डिजिटल मीडिया के प्रोग्राम में गुफ्तगू। निगरान वज़ीर आज़म अनवारुल हक काकड़ से नए नेवल चीफ एडमिरल नवीद अशरफ की मुलाकात। पाक बहरिया से मुतालिक पेशावराना उमूर पर गुफ्तगू। निगरान वज़ीर आज़म की नेवल चीफ को नई जिम्मेदारियां संभालने पर मुबारकबाद। उम्मीद है आपकी सरबराही में पाक बहरिया मुल्क की दिफा में अपना फाल किरदार अदा करती रहेगी। सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट केस की समाअत जारी। कोशिश करेंगे कि वकील अपने दलाइल आज ही मुकम्मल कर लें। आज ही केस खत्म करना चाहते हैं। चीफ जस्टिस काजी फायजी सखी फुल कोर्ट समाअत के दौरान रिमार्क्स। हुकूमत की काविशों की बदौलत मुल्क की मईशत इस्तेहकाम की जानब गामजन है। इंटरबैंक में डॉलर की कदर में कमी, 1 रुपए और 29 पैसे मजीद सस्ता हो गया। इंटरबैंक में डॉलर 281 रुपए और 40 पैसे पर पहुंच गया। ओपन मार्केट में डॉलर की कीमत खरीद 278 रुपए और 50 पैसे पर पहुंच गए। स्टॉक मार्केट में भी तेजी का रुझान। 100 इंडेक्स में 156 पॉइंट्स का इजाफा। 100 इंडेक्स 47,600 से जायद पॉइंट्स पर पहुंच गया। अफगानिस्तान के सूबा हरात में ज़लज़ले से मुतासरा इलाकों में इमदादी कार्रवाइयां जारी। जहां बहक अफराद की तादाद 2400 से तजावुज कर गई। निगरान वज़ीर आज़म का अफगानिस्तान में तबाहकुन ज़लज़ले पर इज़हार अफसोस। मुश्किल की इस घड़ी में हम अफगान अवाम के साथ हैं। एनडीएमए को ज्यादा से ज्यादा इमदाद की फराहमी की हिदायत जारी रखेंगे। वज़ीर आज़म अनवारुल हक काकड़। पाकिस्तान में गैर कानूनी तौर पर मुकीम गैर मुल्कियों का इनखला। डेडलाइन में 22 रोज बाकी। गैर कानूनी तौर पर रिहाइश पजीर अफगानियों की वतन वापसी का सिलसिला जारी। मजीद 48 खानदान वतन वापस जा चुके। अपने मुल्क वापसी पर हम मुतमईन हैं और अपनी मर्जी से वापस जा रहे हैं अफगान मुहाजिरीन। गजा की पट्टी पर इजरायली जहरियत जारी। निहत्ते फलस्तीनियों पर सहूनी फजाई और जमीनी हमलों में मजीद तेजी। शहीद फलस्तीनियों की तादाद 413 हो गई, 2200 जख्मी। इजराइल ने मशरकी अलकुद्स तक तमाम दाखिली और खारजी रास्ते बंद कर दिए। गजा को बिजली खुराक की सप्लाई भी मुअत्तल। शदीद झड़पों में 700 से ज्यादा इजरायली हलाक, 2300 जख्मी। 360 की हालत तशवीशनाक, 100 से ज्यादा गैरकमाल बना लिए गए। गजा की पट्टी पर इजरायली तैयारों के जारहाना हमले। कसीरुल मंजिला रिहायशी इमारतें और 150 से ज्यादा मकानात मुकम्मल तौर पर तबाह। 1 लाख से ज्यादा फलस्तीनी बेघर, 74,000 के करीब मुतासरीन की स्कूलों में पनाह, अक़वाम मुत्तहिदा। गजा की सूरत हाल पर अक़वाम मुत्तहिदा की सलामती काउंसिल का हंगामी इजलास बेनतीजा खत्म। कौंसिल अरकान ने किसी मुश्तरका बयान पर गौर किया, न ही कोई करारदाद पेश की जा सकी। रूस का सलामती काउंसिल से फलस्तीन के बारे में दहाइयों पहले तय होने वाले मुआहदे पर अमल दरामद का मुतालबा। सलामती काउंसिल गजा से इजरायली कब्जा खत्म कराने के लिए फौरी इक़दामात करे, फलस्तीनी सफ़ीर। भारत में मुसलमानों के हुकूक को सबोताज किया जा रहा है। गजा में निहत्ते फलस्तीनियों पर जुल्म सितम के पहाड़ ढाए जा रहे हैं। इजराइल फलस्तीनियों की नस्ल कुशी पर अमल पैरा है। कश्मीरियों के हुकूक को सल्ब किया जा रहा है। मसला कश्मीर अक़वाम मुत्तहिदा की करारदादों के मुताबिक हल होना चाहिए। मशाल मलिक की मीडिया से गुफ्तगू। भारत की जानिब से सिखों को निशाना बनाने के खिलाफ ऑस्ट्रेलिया के शहर मेलबर्न में एहतजाज। मुजाहरे में 2000 से ज्यादा सिखों की शिरकत। मुजाहिरीन ने फेडरेशन स्क्वायर से पार्लियामेंट तक वॉक की। भारत के खिलाफ शदीद नारेबाजी। भारत बैरून मुल्क आबाद सिख रहनुमाओं को खालिस्तान की तहरीक में हिस्सा लेने से रोकने के लिए रास्ते से हटा रहा है। शुरका। आम इंतखाबात के हवाले से इलेक्शन कमीशन की तैयारियां जारी। आवाम की सहूलत के लिए इलेक्शन कमीशन सेक्रेटेरिएट में कायम सहूलत डेस्क और एतराजात वसूली सेंटर सरकारी तातीलात के दौरान भी काम करते रहेंगे। एतराजात कराने की आखिरी तारीख 27 अक्टूबर है। 30 नवंबर को हल्का बंदियों की हतमी इशात की जाएगी। तर्जुमान इलेक्शन कमीशन। पाकिस्तान की शान सूबा बलोचिस्तान। अपनी रंगारंग सकाफत और कुदरती हुस्न से मालामाल बलोचिस्तान पाकिस्तान का एक मुनफरिद सूबा। वतन से बेलौस मोहब्बत के बायस आज पाक फौज में कसीर तादाद में बलोच नौजवानों की है, जो वक्त के साथ बढ़ती जा रही है। बलोच तलबा की फौज में शमूलियत अव्वलीन तरजीह। हुकूमती और अस्करी काबिशों के बायस बलोचिस्तान तरक्की की राह पर गामजन। आईसीसी वर्ल्ड कप का छठा मैच न्यूजीलैंड की नीदरलैंड्स के खिलाफ हैदराबाद में बैटिंग जारी। मैच पीटीवी स्पोर्ट्स पर बराह रास्त। इवेंट में न्यूजीलैंड ने अपने पहले मैच में इंग्लैंड को हराया। नीदरलैंड्स को पहले मैच में पाकिस्तान के खिलाफ नाकामी का सामना रहा। और वर्ल्ड कप में पाकिस्तान क्रिकेट टीम अपना दूसरा मैच कल श्रीलंका के खिलाफ हैदराबाद में खेलेगी। क्रिकेटर्स के मुकाबले के लिए तैयारियां जारी। खिलाड़ियों का आज ऑप्शनल प्रैक्टिस सेशन। वर्ल्ड कप में पाकिस्तान ने अपने पहले मैच में नीदरलैंड्स को हराया था। अस्सलाम वालेकुम नाज़रीन, आप देख रहे हैं पाकिस्तान टेलीविजन न्यूज और मैं हूं हुमा मलिक। अहम खबरें आप जान चुके हैं। अभी फिर से आपको बराह रास्त ले चलेंगे सुप्रीम कोर्ट, जहां पर प्रैक्टिस एंड प्रोसीजर एक्ट केस की समाअत जारी है।
And if you would read Baz Mohammad Kakar's case, in which it was specifically said, where the constitution or a statute does not provide a right of appeal, there is no right of appeal. And if you want to provide a right of appeal in the constitution in exercise of constitutional powers, those have to be provided by a constitutional amendment. And if you want to provide a right of appeal in a statute, then the statute has to be amended, because this right is a creature of the statute or the constitution, and unless the instrument which provides the appeal or unless the law that has to provide the appeal, it is amended, it cannot be provided by implication.
Mr. Zahid Ibrahim,
चले आप अपना पॉइंट तो बताएं ना, हम कुछ नोट ही नहीं कर रहे हैं। I'm not writing anything. I'm just hearing various queries. I mean, can you complete your submissions? Please complete your submissions, and then you can respond to all the queries.
In relation to
Zahid Ibrahim, if I may, on your reading of entry 55, would it be possible for Parliament to make a law creating an intra-court right of appeal in respect of an appeal heard by the Supreme Court under Article 185? Would that be permissible?
Your Lordship has perhaps dealt with that question, where your Lordship has even said, the line that in the end there must be an end.
No, that's review. But I'm saying, क्योंकि आप जिस तरह entry 55 को पढ़ रहे हैं ना, review का तो हमेशा ही है. And my question is, on your reading of entry 55, would it be permissible for Parliament by an act to provide for an intra-court right of appeal in respect of judgment delivered by the Supreme Court while hearing an appeal under Article 185. Would it be possible on your reading of entry 55?
My lord, that would go against the finality principle because
Well,
right of
always.
appeal
Again,
against a right of appeal.
इधर आप
But the logic is
enlarge
that here there is no
अरे
appeal.
enlarge करके भी तो देखे ना, अगर ये section 5 जो है valid है, if it
जी.
is intra vires, petition under 184(3) is filed, whatever happens, appeal is filed, whatever happens, there is a right of review against that.
Okay, so let me answer.
देखिए जो इंट्रा कोर्ट अपील
Let-
इंट्रा कोर्ट अपील इज ओरिजिनल jurisdiction, never appellate jurisdiction. Intra court appeal, so there'll be two streams. One is the original jurisdiction of the Supreme Court. When a special single judge of the High Court passes an order, that is original jurisdiction of the High Court he is exercising, provided under intra court appeal. So that scenario may not be here at all because 184, 185 is already there. We are only concerned with one kind of appeal, which is 184(3) appeal, nothing more.
No, I think
I understand your lordship's question and let me answer it.
आप जितना broadly entry number 55 को पढ़ रहे हैं तो उसकी implications है ना
जी.
अगर उसकी implications fail कर जाती हैं तो that's one thing, उसकी implications alive रहती हैं, that तो इसलिए समझने की बात है ना, या तो आपका केस है कि जी appellate jurisdiction में नहीं हो सकता, further ये power खत्म हो गया, मुझे तो फिर नजर नहीं आता उसमें कोई ऐसी
नहीं,
limit.
मैं ये नहीं कह रहा, मैं वाज़े तौर पे ये कह रहा हूँ कि जहाँ तक power of enlargement है, that exists not just in relation to 184(3), it exists. And my answer is, the line that in the end there must be an end, unless the parliament says so. Unless the parliament says so. That is my.
You're adding words to my words.
Yes, indeed. I'm taking the liberty of adding the words, unless the parliament says so.
I may or may not agree with you.
Subject to your grateful, sir. Sir, if I may move to the next point, this challenge has been dressed up as an issue of independence of judiciary. There is a plethora of case law which identifies that how important, crucial, critical independence of judiciary is to our system. In relation to what constitutes independence of judiciary, what are the things that make up independence of judiciary? My Lord, I will not make your lordships read, but I'll just cite the relevant paragraphs of a few judgments. My Lord, the first is the Sharaf Faridi case, PLD 1994, Supreme Court 105, at page 107.
Please repeat the citation.
My Lord, PLD 1994, Supreme Court 105,
At?
107.
Okay.
The second is PLD 2009, Supreme Court 879, the Sindh High Court Bar Association case, at page 1228, para 17. And lastly, PLD 2010, Supreme Court 61.
No Supreme Court.
2010 Supreme Court?
Page 61. This is, my Lord, Chief Justice Iftikhar Mohammad Chaudhary versus President of Pakistan. And the relevant page is 173, para 157. My Lord, in relation to international treaties and covenants which also define what independence of judiciary is, I have taken the liberty in my concise statement in paragraph 10. I have drawn out what these international treaties say. I will just read one sentence from there, my Lord. Independence of judiciary, according to the Council of Europe recommendations, says, the principle of independence of judiciary means independence of each individual judge should be able to act without any restriction, improper influence, pressure, threat, or interference direct or indirect from any authority, including authorities internal to the judiciary. This is the first definition of independence of judiciary that I was able to gather, which specifically says that from internally from the institution, there has to be independence. My Lord, repeated questions have been raised, but no one has identified which fundamental right affects the petitioners. How independence of judiciary is diluted by this law. An argument is certainly made that once we open this door and allow the Parliament to legislate in relation to even the practice and procedure of the Supreme Court, tomorrow the Parliament may make another law. My Lord, when it makes another law, it will be tested whether they are interfering in the independence of judiciary. And it will be struck down if they do so, but not at present. This law does not. My Lord, most humbly, under Article 184.3...
Zahid Ibrahim, how do you say that? Where the Act obligates the Chief Justice or two other judges to act in a certain manner, and as was rightly pointed out by one of the counsels, they are micromanaging or trying to micromanage or trying to interfere in the independence of the judiciary insofar as the Parliament will now dictate how benches are to be formed or how what cases are to be fixed by the committee or by the Chief Justice, and what would be the number of judges sitting on the benches, and how would the roster be made, and what sort of cases which go before what sort of benches. I mean, if this is not interference in the independence of the judiciary and micromanagement of the judiciary, I don't know what else would be.
My Lord,
I think this is premised. I think we should also realize that this was premised on undermining the office of the Chief Justice. Now, if the office of the Chief Justice, at least I do not read it as the same as the judiciary. I think judiciary means everyone. Chief Justice is a person. So yes, it is premised, but if I use the term independence of judiciary by saying Chief Justice, then we should use the word independence of the Chief Justice and not use the word judiciary. And then the argument goes back and forth, the same one, he's the head of the institution, so he represents the judiciary. I'm not very convinced with it. So I would say, yes, it definitely undermines the independence, or whatever better word you want to say, use not the word independence, but some other word may be better, of the Chief Justice, but not as a judiciary as a whole.
Two very brief responses. Your Lordship should give credit when this law was being debated in Parliament. The very point that your Lordship has said was also raised. And they said...
in fact, incidentally, there are two orders of this court, and the learned Attorney General also undertook to place on record the debates,
in an earlier, my Lord, in an earlier hearing, it was pointed out that it is available online.
If that order
I think it's been placed by
with,
one of the lawyers. It's available in CMA 8565. One day's debate
It's
has
a
been
good
placed.
150 pages.
Some parts of it have been
Achha,
placed
okay,
on the
well,
file.
all I was trying to point out that the questions that your Lordship has raised, the Parliament also grappled with it. And in my humble view, these matters can't be looked in an isolation. Let's face it, I do not know how cases get fixed. I do not know how benches get constituted. I don't know how 184.3.1 case gets presented on the 12th of April, and on the 13th of April it gets fixed.
So, Mr. Zahid Ibrahim,
This itself is a vindication of this law.
can be fixed by the Supreme Court itself.
So,
if you point out
all the Parliament
the
is saying,
Supreme Court
all the,
and the competent authority, which is the full court, which constituted, which promulgated the 1980 rules, they can revisit the rules and fix the issues.
Sir,
how does the parliament come in?
Order 19 of the Supreme Court rules, Order 19 of the Supreme Court rules says that all appeals filed in the registry shall, as far as possible, be heard in the order in which they are set down.
Okay.
Does
So it's a question of implementation. So according to you, the rules are already there, they are not implemented.
No,
so if it is incorporated in a statute, it would ensure implementation.
It is not incorporated in the statute.
Zahid Ibrahim, there seems to be a great fear regarding open door syndrome thing that's going on. So in this case, what we have to identify is whether there is a door or not. So if there is a door, there could come a law which could strengthen us, which would strengthen the Supreme Court, enhance the independence of judiciary. I'm okay with that coming in the door. But if something else walks in the door which affects my jurisdiction, reduces my jurisdiction, violates fundamental rights, access to justice, independence, I strike it down. So what's the fear? What is this open door syndrome going on?
It's a red herring.
And again, Mr. Zahid Ibrahim,
the main question is,
Mr. Zahid Ibrahim, all that the Parliament has done.
Yeah, door is the question that will determine.
The Constitution, for the time being, does not give a door to the executive or the legislature to interfere in the internal affairs of the Supreme Court.
So this bench has to determine whether it all is a door or not. What comes through the door is not my problem.
I think these proceedings are a classic example of how the jurisdiction or the power was exercised by the Chief Justice. As I pointed out earlier, there are a lot more important cases which never get a turn. Now here, everyone is saying it's a good law, but everyone fears this open door syndrome, as my learned brother has said. I view it differently. The Parliament, since this court, having the power under Article 191, was even refusing to call a meeting of full court. And all that they did was to structure the discretion. They have not given any directions, and all that they have done is tried to structure the discretion which this court was refusing to do, and there were obvious abuses.
And the unstructured discretion, my lord, we can close our eyes, but the public confidence in the judiciary has eroded. And we are all invested in this.
I think, Mr. Ibrahim, if I may ask you a question, assuming that this law is, I'm looking at the practice and procedure bits of it now, assuming that this law is intra vires the Constitution, in light of this law, who is the master of the roster?
Well, according to one judgment...
No, I'm talking of the law. In light of this law, who is the master of the roster?
I'm not sure where the term even master of roster comes from.
Who decides which cases get fixed where, etc., etc.?
The committee decides. The committee...
No, you're wrong. Committee is the creature and creation of Parliament. At its broadest level, this law is a claim by Parliament that Parliament is the master of the roster. And I'm asking you a question. You don't have to, as already pointed out by the Honorable Chief Justice, you don't have to agree with the question. To me, this is the crucial aspect of this law. It is not whether the committee consists of 3 judges or 5 judges, or Parliament says let the full court do it, or let the Chief Justice do it. Those variations, as has been pointed out, you said it, maybe that those laws will be made, maybe they won't be made, that's speculative. Whether it is speculative or not, I put that to one side. The point is, and this is the question I'm putting to you,
yes, ma'am,
that in any of those scenarios, including the one that we have before us today, it is not the committee that is the master of the roster, because the committee is a creature of Parliament's will. Parliament has willed it into existence. Therefore, it is Parliament that is the master of the roster. Now, placed at that level, seems to me that this is directly in conflict directly contrary to the principle of independence of judiciary. What would you say to that?
Can the master
I
of the
would
roster,
say- I would
Mr. Ibrahim, can the master of the roster speak? I would add the word the purported master of the roster. When I became Chief Justice, and I looked at it earlier also, the existing rules of the Supreme Court of 1980 stipulate simply that the Chief Justice will constitute benches. Now, practice had developed, maybe it's in accordance with the rules, I can't find it, that every week, list of cases prepared, a list would go to the Chief Justice, this case would go to that judge, and this case would go to that judge, and this case would go to that judge. I have discontinued that practice. This is not even the job of the Chief Justice. This is the job of the registrar. They can be given broad outlines, first in, first out being the general principle. Then there can be fast-track cases, election matters. Naturally, election matter will become redundant after a certain period of time, bail matters, etc. But to see even the cause list of the day and where it goes, I think, and this is the master of the roster speaking, please give me this power so I can use it from the existing Supreme Court rules. Where do I have this power? I can't seem to find it. Can you help me with that?
And Mr. Zahid Ibrahim, there are no masters anymore in the world, you see. If you look around...
He always wants to undermine my authority.
With respect to the master.
Note.
No, but, so I don't see that as a master. So Mr. Zahid Ibrahim, what I want to say is that if you look at internationally, it's about time we wake up to the world, you see. We have US, UK, Germany, Brazil, Nepal, Philippines, just to name a few. There's no such thing as master of the roster. It's a collegial system that works, and that's across the board. And it's about time that we also woke up to all this, you see.
My lord,
with due respect to the master
with
here.
utmost respect, I say we need to wake up to what's outside this room.
You see if I may add to that,
And to answer...
under our system, and I don't mean to be disrespectful to anyone, masters come and masters go.
Yes.
This is not a lifetime appointment.
But while they are there...
No, just a minute. One Chief Justice may have one view of the matter, the other may have another view. And those who come, and I don't mean immediately, I'm not talking of potential Chief Justices sitting here, I'm talking even way into the future, they will do whatever they want to do. But that is not the important point. The ephemeral, fleeting, whether it's 1 year, 2 year, 3 year term of a Chief Justice, of a master, if you want to put it that way, in the more traditional sense, that is, in a sense, beside the point. The question is, within the framework of the Constitution, separation of powers, independence of judiciary, ultimately, who is the master of the roster? And can Parliament lay such a claim and not violate the Constitution? This is the ultimate question.
But if I could just bring in another dimension to this, I don't know if you've looked at this new book called The Court on Trial, and they've done a data-based analysis of the Indian Supreme Court, where they say that invariably through data they've discovered that Chief Justice, if he has all the powers, he can manipulate cases. He can ensure a certain outcome. This is through data that they've presented. They've said that judges who have been dissenting, Subha Rao is one of the judges who dissented several times during his tenure as a judge, but as a Chief Justice he never dissented because they would manage the bench. So this has been through data now established that if one person could get a bench constituted, get the judges on that bench, he could ensure the outcome. Don't you think that sort of directly hits at the core of independence of judiciary?
Of course it does.
And again, Mr. Zahid Ibrahim,
I've also read the book that my learned colleague is talking about, and I look forward to having a very enjoyable discussion about it with him. But the thing is, if the principle, it's the principle that matters. If one man can do it, maybe 3 persons can do it.
Your Lordship,
maybe 5 persons can do it. No, if you don't like following logic to wherever it goes, then the logical answer is everything should go to the full court, but that's practically not possible.
Mr. Zahid Ibrahim.
The point is, the principle of the thing still stands. My question to you still stands.
I want to have the opportunity to answer it. The answer is in 2. First, I would urge your lordships to not read this law as an encroachment into the independence of the judiciary. By no stretch of imagination is this. Even in Parliament, when this was discussed, it was discussed that the bar has wanted to do this for a long time. PTI is challenging their legal counsel. Hamid Khan was cited in the debate as supporting this law. To answer your question, Parliament does not seek to be the master of roster of any.
Not a question of whether they seek to be this
or they have not.
Mr. Zahid Ibrahim.
The principle that is being established is that they are. Whether they seek it or not is beside the point. This is the
Zahid
core
Ibrahim.
of the question.
I would say that it is not. And secondly,
Mr. Zahid Ibrahim,
Just on the lighter
in
note,
most of the jurisdictions,
the only
the
way I
fixation
cannot
of
read
cases-
into this is to keep my eyes closed.
No, is to not chase
Mr.
shadows. I
Mr.
would say
Zahid
not chase
Ibrahim.
shadows. And just one last thing. My Lord, your Lordship had said that, oh, Chief Justices are there for 1 year, 2 years, they go, new Chief Justice come, and it's not you're stuck for this forever. But my Lord, what do we tell people who had homes in Nasla Tower?
I think, no,
What do
sorry,
we tell people who lost jobs, employment, lives, property?
Mr. Zahid
There should
Ibrahim,
be a right of appeal.
ये देखिए, let this message not go out from this court that the constitution and the laws of Pakistan are dependent on who the Chief Justice of Pakistan is. This message must not go out from this court. The laws of the constitution and the laws of Pakistan are there, irrespective of the size of the Chief Justice's foot. So let this message not go out that the next Chief Justice can do as he pleases. Absolutely not. Let that be clear that what the law is, what the constitution is not a variable commodity subject to the whims and wishes of the Chief Justice of Pakistan. That must not be so. And if that is so, that is destructive of the constitution. It is destructive of the rule of law. It is destructive of the independence of the judiciary. It is destructive of everything. If we go that far and say, oh, let the next one come, he'll retire, 25th October, he goes, the next one will come, he'll do his own way. No, absolutely not. He should follow whatever is the proper method of doing things. It's not, I mean, sorry to say, if anybody thinks in that side, Parliament, or in any other situation, that he becomes all powerful, I at least will not let this institution put forward this thing. If we will do as we please when we do. Here we have autocrats writing books, friends not masters. We don't want to even say that. I am not anyone's master. I am servant to the constitution and an abd of the Almighty. That is the place of a judge. It should remain there. It should not be variable commodity. Oh, the next is what? How will he do it? So I don't. This is a very unhealthy sign. If it is so variable, then where the Supreme Court's change laws. I mean, a law is enacted today. The way it goes up, interpreted by one court, by the other court, by the higher court, by the time it comes to the Supreme Court, takes about 20 years for any law to settle. Now, if it's such a variable commodity that we stump everything and we come 184.3, today the law of Pakistan is this.
Certainly we look for consistency
Mr.
and that's
Zahid
what
Ibrahim,
the legal
I
system
think,
should provide.
if I'm not wrong, in most of the jurisdictions, they have adopted objective criteria for fixation of cases and constitution of benches. And they have named it as the natural judge concept. And they have done away with the concept of master of the roster. It's done on an objective basis, laid down criteria, and not on the basis of a discretion vested in one person.
I think it's high time that we bury masters and bring in trustees.
Yes. In fact, the Constitution starts with that word. It's a sacred trust. Because you have mentioned Islam, but I was surprised nobody else is mentioning Islam. I mean, it's mentioned on the streets more than it is in the courts of law.
Most grateful, sir. Thank you for the opportunity.
Mr. Zahid,
Yes, sorry, sir.
बड़ी इनके जो जितने भी मास्टर ऑफ रोस्टर्स प्रेजेंट और फ्यूचर के होंगे, इनसे माजरत के साथ ये देखना है कि इस लॉ में आया ये बताया गया है कि कितने बेंचेस, क्या बेंचेस किस तरह बनेंगे या कौन बनाएगा, किस तरह बनने में और कौन बनाएगा में जरा फर्क होगा।
वो आप लोग आपके ऊपर छोड़ा हुआ है। जिस तरह आपने कहा कि जो अगले आने वाले लोग हैं और जो हैं उन्होंने आप लोगों के ऊपर है, ये पार्लियामेंट वहां पे नहीं फैसला होना है, आप नहीं करना है। ग्रेटफुल माय लॉर्ड, मोस्ट ग्रेटफुल, थैंक यू।
भाई शुक्र है यार।
Who do you represent? My Lord, I represent the PML-N. My concise statement is 8301 of 2023. My Lord, I'm sorry, I have committed the same mistake as some of the earlier councils. जो extracts or foreign judgments थे मैंने अभी दिए हैं। 8301. I apologize, sir. अब प्रेसिडेंट बन गया है।
Sir, I'll keep a mind of it in future, so I'll be careful of it.
ये चला कर 8301 अगर निकाल लें।
There should be a booklet in front of your lordships and the CMA. That is all I will be relying on. May I?
G.
Booklet. Lord, first of all, there's a question of maintainability. At least as far as I am concerned, sir, I'll not be raising that issue. And for the reason that the last time I was on my legs before an 8-member bench, my argument was that due to the public importance and constitutional import of this case, it should be heard by a full court. And, sir, now on merit, sir, there are 3 questions to my mind. Firstly, can Parliament legislate regarding practice and procedure of Supreme Court and in any case override provisions of the Supreme Court rules 1980? Number 2, can Parliament create a right of intra-court appeal against orders under 184(3)? And number 3, whether even assuming the above can be done, do the provisions of the 2023 Act otherwise somehow conflict with any provision of the Constitution? Now, before taking your lordships to the relevant entries and Article 191 and so on and so forth, I'd like to make some submissions, sir, regarding the overall conceptual framework within which I view this issue, and also the background and necessity of the legislation, especially since the petitioners and the counsel for the PTI have directly attributed a malafide political intent behind this act, arising from a desire to subjugate the independence of the judiciary. Now, I agree with the petitioners that issues relating to independence of judiciary do directly engage fundamental rights guaranteed under 9, 10, 10A of the Constitution. But there is a crucial difference between all the previous cases decided by this court, Meram Ali, Rawalpindi District Bar, Liaquat Hussain, Al-Jihad, etc., and this particular case. All the previous judgments of this court basically deal with external threats to the independence of judiciary. My humble submission is that this case primarily relates to internal threats to the independence of judiciary. It is what Justice Asif Saeed Khosa, as his lordship then was, referred to as the final frontier of judicial independence. My submission will be that the constitutional guarantee of independence of judiciary covers both external independence and internal independence. Now, I'd like to start, sir, by reading two short passages from the article of Justice Khosa. He wrote this when he was a judge of the Lahore High Court. So this is page 1 of the booklet. And if your lordship will see page 4, I'll read a couple of passages from there, and page 6. So the second para, page 4. Now I come to the fourth stage, which I call the final frontier. In my capacity as a lawyer, I had written and spoken about independence of judiciary on several occasions, but now my perspective and angle are slightly different. Having spent a good number of years on the bench, I have seen the system from within, and thus I know and understand a few things which an outsider may not be in position to appreciate. In this background, I intend to share some aspects of independence of judiciary which are generally overlooked. But these aspects are so important that without attending to them, the whole superstructure of independence of judiciary remains incomplete, and if I may say so, shallow and superficial. I'll skip a para, sir, to save time, then the para after that. It is some of these areas and aspects, often ignored and overlooked, which I intend to highlight. The earlier stages I have mentioned are essentially relevant to threats to independence of judiciary from outside the judiciary. But the final frontier envisioned by me is the stage where independence of judiciary is achieved through a successful passage of the earlier stages, is to be protected from the threats originating from within the judiciary itself. Three areas appear to me of particular importance in this context: independence from oneself, independence from judiciary, and independence from justice. Now, if your lordship will turn the page to page 6. In the first part of the final frontier, he deals with how judges have to rise above their own personal inclinations, ideological inclinations, biases, and so forth. And then the second part is discussed here. The second aspect of the final frontier is the independence of an individual judge from the undue pressures of his peers and from unnecessary or unwarranted controls of his institution. There is no doubt that in his capacity as a judge, a person performing judicial functions is necessarily a part of his institution, i.e. the judiciary, and ordinarily his functioning is to be in line with the overall policy and scheme of the institution. However, the problem comes when the institution's independence is itself under cloud because of extraneous factors, and an individual judge starts abdicating his decision-making before the dictates of the institution, or conversely, when the institution starts excluding an individual judge from decision-making in sensitive matters because that judge is not likely to toe the line of the institution. Both these factors, which may be unthinkable in the civilized world, are unfortunately real possibilities in some other parts of the world and completely undermine the notions of independence of judiciary.